The next matter to come before the court this morning is State of Ohio versus Craig Coffman. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you let me know when you get started, I'm keeping a clock this morning. I can keep you apprised of the passage of time should you wish to reserve any for rebuttal. We read the briefs and are ready to see when you are.
Thank you. Robert Cabrera on behalf of defendant Craig Coffman. I would ask to reserve 3 minutes. Would indicate to the court that we are here this morning. Craig Coffman, the defendant, is appealing his conviction by a jury trial of a not guilty finding on count 1 of felonious assault, but guilty of a lesser included offense of assault, and guilty of domestic violence. He was in fact sentenced to 17 months in prison and served those 17 months. He was released yesterday. Your Honor, in regards to the facts, many of them are undisputed. The Coffman and Leanne are brother and sister and have lived together for a period of time off and on, and were living in the same home on the day of the situation which occurred at their mother's home in Lorain, Ohio. Likewise, Tony is the boyfriend and Frank is the police officer. Essentially, those are the 4 main witnesses in this matter. Coffman and Leanne lived together for a substantial period of time, and at the time the situation occurred, I believe Leanne had a room fixed up in the basement where she lived on occasion. They were together that day. Coffman apparently had driven her to work and was waiting for her to end work. At some point, she decided she did not want to go, and so he left and went home. Shortly thereafter, several hours later, she returned to the house. Coffman was in the home at the time, and apparently she was dropped off by 2 other women and approached the women and at some point talked to them. Then, of course, the versions of what occurred are different. Coffman's version is that he was cooking, that Leanne went downstairs. At some point, he went down to talk to her, that Tony pulled up. He heard some type of a verbal confrontation. Tony leaving, he went downstairs, and at some point Leanne was sitting on the bed, disheveled, and Tony punched him and essentially chased him out of the house, where he then went to a store and at some point had a discussion with a police officer. Leanne's version is, of course, completely different. She indicates that when she came home, there was an altercation about his drinking and the condition of the house, that at some point he wanted to go out and purchase more beer. She was not going to let him do that with her mother's car. So apparently, in her words, that at that point Coffman punched her on the left side of her head. She fell flat on the floor with her head up against the wall. Felt another blow to her face, that he was straddling her across her chest. I repeatedly punched her in the face. At some point, started ripping her hair out, scalp and all. And at some point, he told her he was going to kill her, and then licked her in the face. Got up off the floor and went downstairs. Grabbed a baseball bat and hit her over the shoulders with a baseball bat. And apparently stopped when he heard pounding on the basement window. Your Honor, if it seems odd that the defendant would sort of highlight these events, it's only because obviously the issue before the court is the manifest weight and the sufficiency of the evidence that was presented. And this was the evidence that she testified to. The jury at some point apparently did not believe her, because I would argue that each and every one of those qualify for serious physical harm, which would have been the element that was required in regards to felonious assault, yet he was found not guilty. So Tony did testify as well. He said when he came home that somehow Coffman let him into the house, and when he saw what had happened, that he started a fight with Coffman, and at some point chased him out the front door. Your Honors, the truth of the matter is, I did not represent the defendant at trial, did not present the evidence. So like this court, we read a cold transcript, and the first thing I think of is the defendant got convicted. So how does he get convicted? I should be able to read through this transcript and know exactly how he gets convicted. I should be able to point to the error and say, boom, there it is. This is what the jury felt was important enough to like convict him. I couldn't find it in this transcript. In fact, let me suggest, first of all, that I believe that this trial was a very sloppy trial presented by both the prosecutor and state, and the defendant. And likewise, the judge's jury instructions were, I think, a bit confusing and a little bit sloppy. In the past, I used to think that it didn't matter how you presented, justice would prevail. Now I'm beginning to believe that these type of, in terms of due process, a notice opportunity to be heard means a fair, honest opportunity or presentment of the evidence. And I believe now it disadvantages the defendant, and I think this is a perfect example of how it disadvantages the defendant. I can't ask this court to ignore the jury's determination. All I can ask the court to do is to question as to how they arrived at that conclusion. He was charged with felonious assault and domestic violence. There was no witnesses to the event. It was essentially her word against his. There was evidence presented. The court's aware of that. There were some pictures that were taken. Pictures of the baseball bat, which I'm not sure why, but there was a bat apparently in the house. Obviously, the evidence was presented to corroborate the testimony of the defendant. And thinking from an objective perspective, the jury should have found him guilty of felonious assault. They did not. They found him guilty of assault. Well, I understand the concept, at least I think I do, of a lesser included offense regarding the elements of assault, but it doesn't, to me, if she were believed, then he would have been convicted of the original offense, felonious assault. It doesn't make sense for them to convict on the lesser amount if they didn't believe what she said originally. Because the elements of assault are different than felonious. There's no serious physical harm, or actually physical harm. It's not a battering case. But the jury would have to believe that the state proved each and every element of the offense. And that could have only been by her testimony. So in my view, her testimony just was not credible enough. And I think part of it was the presentment of the evidence. I think part of it was the judge's jury instruction, which I found very problematic. He says, one of the things I'm going to tell you is the testimony of one witness that is believed by you is sufficient to prove any facts in our judicial system. And he goes on and he says, it's amazing. I've done this for so many years. I go back and talk to my jurors, and I've conducted probably 950 jury trials. It's a lot of jury trials. I have talked to tens of thousands of people, and it's amazing how many times people tell me, well, there was only one witness. And then I would always respond, do you remember that? But the idea of, was that the proper addressing of the subject? If a person sits there and says there's only one witness, isn't that person sitting there saying, I don't think there's enough evidence to convict? That's really what they're saying. And the judge should sit there and say, if you believe that that one witness has enough testimony or believe that witness testimony, then you have enough evidence to convict. He doesn't say that. It sort of makes it an objective standard. One witness is enough to convict somebody, regardless of what that witness says. And I don't think that that's a proper instruction for a jury, particularly in a case like this where the evidence may or may not be corroborated. I mean, we have a police officer, which is also perplexing in regards to being sloppy. CSI on television, all these different programs about how investigations are supposed to be conducted. And we have an officer that comes in, and I guess I'm not sure exactly how to say it. I understand that their job is difficult. I understand that I respect what they do. But this is a situation where he knows what's going to happen. Charges are going to be filed. Defense attorneys are going to come in, and they're going to start defending the defendant. It would be to his best interest to collect as much credible evidence as possible, to follow up on that evidence, and to present a very solid case. This may not have gone to trial had that happened. Takes a picture of a baseball bat. Is there any? Any connection to that baseball bat? Did they fingerprint the bat? Did they do a DNA on the bat? And I'm not a forensic expert. My idea today was not to challenge forensics, but I do believe that that's what's necessary. There's something in terms of protocol that are established that need to be followed, and there surely must have been protocols in this case. So he goes to the crime scene, the alleged crime scene, and he talks to the two people, and then leaves. If he gives instructions, she didn't understand those instructions because he comes back or he calls the next day and has her come inside, tells her, well, maybe you should go to the hospital, maybe you should do this, or take some pictures. I believe he may have taken the pictures when I was and so the trial goes forward, and then the jury is presented with this evidence, and at some point it's a conflicting situation. It should not have been. I think it should have been a slam dunk for the state, and I think they should have got a conviction based on her testimony of all, if believed. Likewise, if not believed, then they should not have gotten a single test.
Gave some contradictory statements, so too, right?
I'm not sure, Your Honor, in terms of contradictory statements. The police officer says one thing. Trials come back a year later from the night of the year and a half or what have you. I guess, I think despite what I said in terms of a trial, I understand they are not perfect. They can't. Just the way the memory works, the period of time that's lapsed between when it actually occurred. But assuming he did, when is it important for him, in the discussion with the police officer, is he under oath to tell the truth? Number one, when he comes to trial, is he under an obligation to tell the truth? Yeah, the judge swears him in and requires that he does that. So sometimes inconsistencies in regards to police officers, I'm not so sure is as credible, unless it is an overwhelming sort of admission or whatever. Yes, I did this, and I'll do it again tomorrow. And then at trial, well, I didn't really say I did it. I said I might do it or something of that nature. That might be an inconsistency.
And counsel, you're just now reaching into your 3 minutes of rebuttal time.
Thank you, Your Honor. This time I will concede to my counsel.
Good morning, Your Honors. May it please the Court. Mary Solansky on behalf of Appellee in the state of Ohio. This case comes down to credibility, essentially. In this case, what the court has to look at is, did the jury lose its way when they determined that Leanne was credible when she said that the defendant beat her? Well, Mr. Cabrera makes much of the fact that originally the defendant was charged with felonious assault, but he was only convicted of the lesser offense of assault. As this court has held numerous times, and I think throughout Ohio it's been held, that the jury is free to believe all, part, or none of the testimony of each witness that testifies. And I think in this case what you had was there was an inconsistency in the medical records with what Leanne said. First, the jury had to consider the fact that she didn't go to the hospital right away. It wasn't until the next day when the officer insisted that she go, about 24 hours later, that she finally went to the hospital. When she got there, at the very beginning of the medical records, according to the testimony at trial, it stated that there was really, that the swelling in her eye had gone down and that she didn't have any vision problems. And the victim was cross-examined about that statement because her testimony at trial was, he hit me, my eye was swollen shut, I couldn't see, and I still have blurry vision in that eye even right now. It's getting better, but it's still a little bit blurry. And the victim was cross-examined about this statement in the medical records that there was no vision problem, because here she is a year later saying, I had this vision problem. And the victim pointed out that later in those very same medical records, it talks about the fact that her eye is completely swollen shut. So there's that inconsistency within the records that kind of is, I guess, casting doubt on what the severity of the injury was. But I wouldn't say that it cast doubt on her testimony that her brother was in fact the person that assaulted her and caused the injuries. And the jury in this case obviously chose to set aside that testimony about the severity of the injury and ultimately find the defendant guilty of the lesser included offense of assault. And as this court held in State v. Robinson, that's within their purview. That's what they're permitted to do, to look at that. And I think it also highlights the fact that in this case, with so many different versions of events and some impeaching evidence coming in about different parts of the case, the jury really obviously took a very hard look at the evidence. I think that that's what that lesser included offense tells us, that they didn't just say, well, you know, there's some of these issues, which as anybody knows that's ever tried a case or even served on an appellate court, trials aren't always perfectly clean. You have these issues, you have these witnesses, and you take them as you find them. I think that when you read the transcript, one of the things that is going to come through is that the victim kind of had an attitude at points when she was being cross-examined. She got very angry, you know, and very emotional. And so to say that, you know, this was a sloppy case and it wasn't tried well, you take your witnesses as you find them. And the defense had to take their witness as they found him, in this case, the defendant. Because remember, whose testimony in this case was seriously contradicted by things that they said and did? It was the defendant's. He first says, well, I got to Circle K, I walked across the crosswalk, and I walked up to, I saw a police car, and I walked up and I talked to the officer, and I told the officer, you know, that he mentions Tony, the boyfriend, the ex-boyfriend, you know, that there'd been some kind of altercation. Well, it's not at all what two other witnesses, a police officer and Tony Petito, testified to. Mr. Petito said the defendant ran out of the house. I believe he admitted that he did strike or tussle or fight with the defendant when he saw the victim had been attacked and beaten up. The defendant runs out of the house and Mr. Petito says, I'm going to follow him, because the victim is at that point saying, I don't want to call the police. So he gets in his car and he goes to follow him, and as he's looking for him, he comes across Circle K. He's from Parma, so you know, he knew where the victim lived, but he wasn't very familiar with the area. He said he couldn't call the police because his cell phone was in his coat pocket that he had left back at the house. So he went inside and he spoke to the officer, and he told the officer, my friend was just beat up by her brother, you need to investigate. The officer was getting coffee, you know, it doesn't appear there's anything, you know, I guess there wasn't a sense that there was some ongoing situation, and he said, well, let me get my coffee and, you know, get out of here, and then I'll follow you over and I'll look into this, I'll investigate it. And so Mr. Petito goes back out to his car, and he's sitting in his car waiting for the officer. The officer's come out, got in his car, apparently he's not ready quite to pull away immediately. And in the meantime, the defendant, according to the officer and Mr. Petito, comes walking not through the crosswalk, but around the back of the building, and Mr. Petito jumps out of his car and he starts talking to the defendant, and he says, you know, I told that officer what you did, you need to go over there and tell him what you did. And he's pointing. And the officer testifies that he sees all of this, and that his perception of what's going on is that Mr. Petito is telling the defendant, go talk to that police officer. For whatever reason then, possibly because he had struck the defendant, Mr. Petito drives away. The officer starts motioning for the defendant to come over. He doesn't come over right away, so the officer puts his window down and kind of rolls up a little bit. The defendant walks up to the car, and the officer says, hey, you know, that guy told me that you assaulted your sister. Defendant says, oh no, she came home drunk and fell down the stairs. Well, one point I want to make before I go on about that is there was no evidence to show that a fall down the stairs could have caused this, that there was something sticking out of the floorboards, that they were in disrepair, that would have ripped chunks of her hair out. But back to the story that the defendant gives. The officer doesn't arrest the defendant at that point because all he has is conflicting stories from two people who are not the victim. So he says, I had the defendant's information up on the computer, I knew where he lived, I drove to the house to investigate, and when I got there, I saw the victim, I saw all these injuries. The defendant testifies at trial, and he doesn't say at trial, oh, she came home drunk and fell down the stairs. He comes up with a different theory of what happened to try and his self-serving testimony to to try and exonerate himself in this. He says, well, I was upstairs watching TV and the ex-boyfriend was downstairs with Leanne and I heard, kind of like a scuffle. And so he's sort of implying to the jury, hey, it was the boyfriend that beat her up, not me. So that's his own testimony is contradictory to what he told the police officer. And not only that, the police officer's testimony is further corroborated by the fact that, or I should say, the defendant's testimony is discredited by the fact that he has a completely different version of events than what went on at Circle K. He could have said, well, I talked to Tony and then I went over and talked to the police officer. He could have said that. He didn't. He tried to make it as self-serving as possible. I walked through the crosswalk across the street up to the police car and told the police officer what happened. That he had been assaulted and that his sister had fallen down the stairs. And it's not credible. And in this case, I think that the issue about the felonious versus the misdemeanor assault aside, the jury was able to kind of parse that out and say, okay, well, we have some concern about the seriousness of the victim's injuries, but there's so many other things that are consistent with her saying that her brother is the person that beat her up. And there was no doubt that she had been beaten up. There was an assault. The only question was, who was the person that assaulted her? And the evidence, in this case, the manifest weight of the evidence is supported by all the interlocking statements of the various witnesses that corroborate each other and contradict the defendant. And the defendant couldn't even tell the same story at trial because it would have been perhaps easier or even smart for him to get up and say, if it were the truth, hey, she came home drunk and fell down the stairs. And not only that, the officer testified she didn't smell of alcohol and she didn't appear to be drunk to him. And she admitted that she had one drink after work, that she'd stayed about an hour, and she worked at Sebastian's, a bar. When you look at this as far as the sufficiency of the evidence in this case, this court...
Counsel, I need to inform you that you've reached the end of your time this morning. Thank you.
Well, with the sufficiency, I think that the manifest weight supports that as well. Thank you.
Thank you. Just briefly, as I said earlier, I can't ask this court to ignore the jury's decision. The decision is there. However, I go back to first year law school. The starting point is that a defendant is innocent until proven guilty beyond a reasonable doubt. Not any doubt, but a reasonable doubt. Likewise, that's what our function is. Our function is to make sure that it was done right, done fair. The umpires, this court is an umpire. Of course they found him guilty. But, we have baseball games, you have umpires. You have football games, you have referees. You have basketball, you have referees. That's what this is all about. Is it fair for what happened? It's guilt beyond a reasonable doubt here. There was doubt. How about if Tony had been charged? He had the opportunity. In fact, Coffman testified that he actually helped his sister down the stairs. So there was a stairs sort of version. In fact, the whole point of a trial is we don't know, and we will never know. The jury's presented with the evidence, and then they determine what happened that night. There were no direct witnesses. There are no videos or what have you, where there's one person's word against the other. And yes, it is the view of the trier of fact to determine, to tell us what that reality was. But then it's our function, my function, to present to the court what I believe that they missed the boat on, and then have this court evaluate that as well. That's the process. And just because the jury found her guilty, the counsel stating that they just elected to set aside, sure they have the right to set aside evidence. In this particular case, there was some pretty important evidence, pretty damning evidence that should have been considered and should have made a huge difference. The eyes swollen shut and still pain a year later. Your Honor, it was incumbent upon the state to prove each and every element of the defense beyond a reasonable doubt, and I believe they failed, and I'm asking this court to consider the arguments that was presented and to reverse this matter for further determination. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides, as well as posted on the Supreme Court website. Thank you.